Hi, everyone. I'm Lisa Heslop, and I'm associate at the Center for Research and Education on Violence Against Women and Children here at Western University. On behalf of the Awareness to Action Project, we thank you for joining our webinar, An Effective Family Violence Screening Tool for Mediators, the MASIC-S. Next slide, please. I want to start with a land acknowledgement. Please think about the traditional lands that you're situated on and join us in acknowledging and thanking the generations of Indigenous peoples who have cared for these lands and in celebrating the continued strength and spirit of Indigenous peoples. The ongoing work to make the promise of truth and reconciliation real in our communities, and in particular to bring justice for murdered and missing Indigenous women and girls across the country should inform our decisions in this event and beyond. Next slide, please. This webinar is part of our Awareness to Action project. The A to A project is a collaboration between our 5 sister alliance research centers in Canada on gender-based violence. It's funded by the Department of Justice Canada, and the project has 2 primary goals. The first is to enhance training opportunities like this for gender-based violence and family law specialists to better support trauma-informed practices. And the second is to build an online guided tool to create parenting plans in cases where there's been family violence. Next slide, please. We encourage you to check out our website. We post a number of things there, briefs, which are summaries of research topics relevant to serving survivors in the family law system, and legal bulletins, which are short summaries of recent and important court documents related to family violence, court decisions rather, and recordings like this and all of our webinars are posted there. Thank you. In today's webinar, we're happy to be joined by leading experts in the research and practice of dispute resolution in family violence cases. And they're going to join us here to discuss the importance of screening for family violence, introduce the MAISIC screening tool for mediators, share the latest research and tips and tools for professionals to achieve best practice standards when helping to resolve family law cases where there's been family violence, particularly those where there are serious safety concerns and power imbalances arising from that violence. And I have the distinct pleasure to welcome and introduce our panelists for today's webinar. First, I'd like to introduce Amy Applegate, who is a clinical professor of law and a Ralph F. Booch Faculty Fellow. I don't want to say that too many times, and the director of the Civil Protection Order Clinic. Amy joined the faculty at Indiana University Maurer School of Law in 2001 after a career in private and government practice. She has introduced screening for intimate partner. She's introduced screening for intimate partner violence in clinics seeking civil protection orders at the clinic, and has also taught mediation theory and practice in the clinical law program that she developed at the law school. Amy has received teaching, research, and service awards for her work. She has been a leader in clinical legal education on the national level in the United States, and actively and significantly involved in state and local bar activities with special emphasis in the areas of delivering pro bono services, training mediators, and mediation ethics. Next slide, please. The second member of our panel is Annamaria Walsh. Annamaria is the director of the Alternative Dispute Resolution Division of the Appellate Court of Maryland, where she supervises a team of highly skilled staff attorney mediators and manages the daily operations of the division. In addition to her supervisory and program development roles, she coordinates civil appellant cases with senior judge mediators. She screens for cases of appropriateness, and she prepares orders and remands to dispense of pending appeals. And finally, next slide, please. It is my pleasure to welcome Hilary Linton. Hilary practiced law in Toronto before founding Riverdale Mediation in 2021, which provides family mediation, arbitration, and parenting coordination. At Riverdale, she works with a team of lawyers and a retired judge to deliver high-quality dispute resolution services. Hilary has designed standardized procedures for screening at Riverdale, which incorporate the MASIC and more recently the MASIC-S tool into the protocols for mediators. She is a member of the advisory group that developed the Federal Help Toolkit, identifying and responding to family violence for family law legal advisors, which is published on the Justice Canada website. And she is also the author of the Ontario Judges and Lawyers Guide to Safety Planning, which can be found in the Ontario Family Law Practice, Volume 2, 2024. So now, without any further ado, I would like to turn this over to our speakers. If you have any questions for our presenters, please remember to type them into the Q&A box.
Thank you, Lisa. I very much appreciate that introduction. So I'm very happy to be here speaking to you today. I'm Amy Applegate, and I just wanted to acknowledge briefly here on the next slide that we in the United States typically refer to domestic violence and more recently intimate partner violence, which we call IPV. And I know in Canada it's family violence, and they're really quite comparable, although it's a broader term than what we use. But we are here to, today to talk about what we know about mediation for separating and divorcing parents who have high levels of IPV. I would just briefly note that for many years, the assumption in our country, and I understand in yours as well, and from the US, I think that's probably obvious, the assumption was that there shouldn't be mediation for couples who had a history of IPV. What is interesting is that many people who firmly held this view were not actually screening for IPV and may not have known whether they were actually mediating cases involving IPV. So we will be looking in a bit at how to screen for IPV, but my colleagues, Anna and Hilary and I decided that we would start with just about what we know now about mediation for this particular population. It started actually for me in about 2005. I started collaborating with some of the people whose names you see on the screen. And we started doing research, and eventually we were able to actually do a large randomized control trial to compare outcomes for parents who had serious histories of IPV, whether they went to court, which was what the norm was, as opposed to some form of specialized mediation. And we were very lucky to get funding from the United States Department of Justice. They have a National Institute of Justice, so we got funding for this. And a randomized control trial is actually the gold standard of empirical research. We did our study that we currently have. We're finishing up a study that we did where Anna Walsh works in Baltimore. We don't have findings to report there, but from the Washington, D.C. study that we did, we worked with the Multi-Door Dispute Resolution Center, and they were part of the D.C. Superior Court. This was a court-annexed mediation program that had experienced mediators. We dealt with a population that was 73% unmarried, 86% African American. The court was referring virtually all family law cases to Multi-Door, and the default method of mediation was joint in-person mediation. There was screening being done by Multi-Door. We had done some research with Multi-Door prior to this big study about screening, and I'll be talking about that in just a little bit. But they were sending back cases if the level of IPV was too high to be deemed appropriate for the parties to sit together in mediation. So we were very excited to do this study. We had two forms of specialized mediation. Shuttle, which you can see here, was separate rooms, and most of you probably know this, separate rooms. The parties were never together. The mediator shuttled back and forth between the parties, and they did not see or hear each other. And the other form of specialized mediation, we called it video conferencing. Today, in a post-pandemic world where we have now started using Zoom all the time, today we would call this online joint mediation. But back then we were calling it video or video conferencing mediation. The parties were physically present at multi-door, but they were in separate rooms, and they could see each other and the mediator on a screen. The mediator was in a third room, and they could see and hear each other, but there were safeguards built in. So if it didn't go well, one or both parties could get out of that joint meeting. And then, and so it wasn't expected that the parties had to mediate on the same screen together for the entire mediation. So we had 49 cases go to shuttle, 50 cases go to video, and 67 cases went back to court without court annex mediation. We actually assigned comparable numbers, but not all the mediation cases started for, well, probably for reasons that you might understand in your practice. Not everybody who has experienced IPV is going to actually show up, even if they agree to participate in the mediation. We collected data from the mediators, and we at 2 times, at the start of the study and then at the end of each case that they mediated. We collected data from the parties 3 times at the start of, for them when they first intersected with us, right after their case was resolved, and then a year after they entered the study. And then we also looked at court records 1 year out from final resolution. So now I'm going to talk to you about what the mediators reported to us, and it was quite interesting. They didn't have any significant difference in feelings of safety in either of those 2 mediation conditions, and they weren't reporting significant amounts of difference in time spent mediating them. But there were in fact some differences. As a trend, the mediators were, well, as trend in terms of statistical significance. So in other words, there's a difference between trend and statistically significant. So here it's just a trend level that the mediators were more comfortable or satisfied with shuttle as opposed to video, and they found shuttle more appropriate. But there were statistically significant differences in how the mediators felt that about the approach, which they thought that video should have been handled with a different approach more than this happened for shuttle. And it was a significant difference for shuttle versus video, having a positive impact on the outcome of the case and the ability of the parties to reach an agreement. Let me move my thing here. The parties felt pretty positive about mediation, the 2 forms of specialized mediation, immediately after their mediations. Compared to both forms of mediation compared to court, parties reported feeling safer and less upset. Males felt safer and less fearful than females, excuse me. Parties were more satisfied with the process. They were more comfortable with the process, more satisfied that their concerns had been heard and understood, that the process was fair, that this required them, the parties, to be more respectful to each other, that it was a more appropriate process, more comfortable that the parties would follow the terms of the resolution. So that was a pretty impressive set of preferences from the parties. But there were, of course, many areas in which there were no statistically significant differences. And across any of the study conditions, either mediation, either form of specialized mediation, or being sent back to court. And this would have been in, whether the process would result in positive family outcomes or positive financial outcomes, and generally satisfaction with the outcome, the final resolution, if there was one, or not having reached a final resolution for those who did not reach a final resolution. The agreement rates were quite interesting. I have a couple of notes I wanted to supplement for you. So video was half as likely to reach settlement as shuttle or return to court. That was very interesting. So, and the percentages were generally low in terms of agreement rates. I would note that multi-door is a very facilitative program. So almost all of the mediators endorsed facilitative, maybe one endorsed transformative, but they saw themselves as facilitative mediators. So 22% of the video cases reached settlement, whereas 43% of the shuttle cases reached settlement. But actually in mediations not involving higher concerning levels of IPV, 47% of cases were reaching settlement. Obviously, those who went to court, there was very high rate of resolution because the court usually decided it. Although I would say that I think it's fair to say that almost all cases got resolved if they were sent to court, unless there was some sort of dismissal. And even that would be a resolution. The time to final resolution was quite interesting too. Court cases took much longer to resolve than either shuttle or video mediation. Court took 243 days on average, whereas shuttle took 70 days to complete from start to finish, and video 79. So, and that was not significantly different between the two specialized mediation forms. There were, in general, in terms of the resolution of the cases, you didn't see a lot of differences between how the cases were resolved, which means that parties were agreeing to things in court, similar to the outcome in mediation. There were a few significant differences for people who wanted to, well, there was more first option childcare when one of the parents couldn't be available. That was more likely to be addressed in both forms of mediation. And both forms of mediation included substantially more restrictions on and aspirational language about the communications between the parents. Much to our chagrin, we found that in mediation, the parties were, both forms of the specialized mediation, the parties were more likely to have child exchanges take place at parents' homes. And that was, to us, that was disappointing to us. In terms of 1 year later, I would say that there were some even more interesting developments. Okay, there still was higher concerning IPV being reported, but they were at significantly lower levels. And there were no significant differences across conditions. There were low relitigation rates across all of the conditions. Most of the positive differences for specialized mediation were no longer being reported. So it was a much more level set of responses, but there were some other findings that I would like to share with you. There was a trend that that parties who had gone through video as compared to shuttle were experiencing PTSD from the other parents' perpetrated IPV and harassment. Shuttle was parents who had gone through shuttle were expressing more positive co-parenting. This isn't a trend, and positive family outcomes. Court, this too was, we've never been able to figure out quite why, but the court, when parties were sent back to court, they had higher levels, significantly higher levels of perceived social support. We had some guesses, but they're just guesses. But generally, there were no significant differences across conditions. Somewhat disappointing was that mothers across all the conditions were reporting their children at risk for further problems. And that, that is worrisome. Based on our study and the outcomes and other research, these are the recommendations of my colleagues of my, my colleagues and I make these recommendations. We believe that this research shows that mediation approaches designed to protect party safety can be a viable option for some cases with higher concerning levels of IPV. Relative to sending a case back to court, mediation can be better and immediate outcomes and time to resolution and can do as well over a 1-year period. We think that specialized mediation can be appropriate for parties with high levels of IPV, but with these caveats. We're recommending that mediators and anybody involved in mediation start with shuttle as opposed to video conferencing or joint online mediation. Use video or online joint cautiously. When parties are appearing in person for specialized mediation, you need a safe environment. Multi-door had a lot of security. If you do not have that kind of security, rethink whether parties with high levels of IPV in their past should be coming to your operation. And we do not think that when you identify a couple as having higher concerning levels of IPV that you should ever do joint in-person mediation. Finally, we would say that parties who have this kind of history should not be mandated to mediate. Remember that the people that we studied were people who were willing to take a 2/3 chance to have specialized mediation. So whether mediating or not mediating cases involving high or concerning levels of IPV, you have to have appropriate screening that's conducted before mediation, and that should continue through the process. I think we know at this point through research that the existence of IPV in a couple or family is often not recognizable without proper screening, because many people who experience IPV do not disclose that to others. They don't pursue orders of protection. They don't call the police. They don't press criminal charges. When they go to the hospital, they don't say what's really happened. Not all, but many do not do these. And so we have done some research in this area. It started in my clinic, these 2 studies that are currently on the screen. The first one was in my study when I was when the collaboration that I had with Amy Holtzworth Monroe and Connie Beck started, and we looked at how we were screening, how my students and I were screening in our clinic compared to a comprehensive behaviorally specific IPV screen. The first one we studied, which was in my clinic compared to clinic screening, was the RBRS, the Relationship Behavior Rating Scale. And I'm going to explain comprehensive behaviorally specific IPV screening in a moment. And then we also, after we did that study, which showed that we really should be doing these behaviorally specific screening in my clinic, I worked with Amy Holtzworth Monroe and Connie Beck, and we tried out in my clinic both the RBRS and the Dove, but it decided the Dove is actually a Canadian screen, which many of you might know, Desmond Ellis, a very impressive person. We decided to create our own screen, which is what we're going to be talking about today. So we created the Mediators Assessment of Safety Issues and Concerns. We were looking to build on existing knowledge and to use behaviorally specific questions. So not, are you a victim of violence, or were you injured? It more specifically, did the other person hit or punch you? Did they strangle you? Did they follow you? Things of that nature. It was a longer screen than what we're currently distributing now, but it was conducted as an interview during intake with parties separately. We prefer to do the screening with the mediator, but if not, if there's somebody who does the screening, it should be shared with the mediator if at all possible. Each party reports on their own IPV victimization, not their perpetration, because at least in the United States and many jurisdictions, if you admit to crimes, you may, to a mediator, the mediator might get brought into the criminal case as a witness. And what we tried to do is we had this on a paper version, which we made freely available, and it didn't need much in the way of training. In fact, many people just started using it without training. We introduced the MASIC in 2010 in the Family Court Review, and some people, some of you in the audience may be familiar with this. There were 37 items about IPV. It was multidimensional, so it included psychological abuse, and that would include verbal abuse as well, coercive controlling behaviors, threats of severe violence, and then physical violence, whether, I hate to use the word moderate, but that would include severe physical violence, as well as the less severe physical violence, sexual violence and stalking. We also had 2 areas of questions about the consequences of IPV, injury with a focus on severe injury and fear. We have done a study, and that was led by one of the students in the program, and that demonstrated evidence of the reliability of the MASIC and the validity of the MASIC. It's here. And I would say that we had a lot of positive reaction to the MASIC. It's been used in many places. This is the full one, the paper one, by mediators and mediation programs. But we did get a lot of concerns about the length of the screen, particularly with court annex programs that had time limitations, and even private mediators. And so those concerns that we kept hearing about, can you shorten it? Can you shorten it? And really, there's no 5 magic questions that get you to understanding domestic violence. But we did decide we were going to try to shorten the screen. And this was done by Fernanda Rossi, a member of our team, working with us, using a statistical program called Item Response Theory. And she was able to identify the IPV questions on the MASIC that identified the parties reporting the highest level of IPV. So she used data from the MASIC that had been, we studied this in basically in the US, that would be my clinic and DC, and 2 clinics in Australia. So we had 904 mediating parties with their reports. That was really impressive. And because of that, we were able to work with Fernanda. We took the items that she had identified as the most worrisome in the MASIC, and we created the shortened MASIC. We call it the MASIC-S. There are 2 versions. Today we'll be presenting the MASIC-S. I'll talk to you in a moment about the MASIC-S with the danger assessment. What is we think is really helpful about the shortened MASIC is that it is administered online. There's automatic scoring. There is branching logic. So if certain questions are answered in a certain way, you move on to another section. This increases efficiency, and it's individualized to each party. We did our first work in Maryland with Anna's group with the MASIC-S with the danger assessment. And while that is a terrific tool, it's a tool that was developed by Jackie Campbell and her colleagues at Hopkins University. It asks questions that empirically predict the risk of lethality towards women in abusive relationships. And it's a terrific tool, like I said, but you need specialized training, and that was inconsistent with our plan to make this widely available to all mediators and even attorneys. We have a type now for attorneys as well. So we introduced the shortened MASIC just recently, just this past year, in the Family Court Review. It felt good to introduce the shortened one in the same place where we had introduced the first MASIC. And at this point, I'm going to be turning this over to Anna Walsh to talk to you about what we were doing with the shortened MASIC. I will say that it is supposed to be easy to use, and I think you will find it easy to use. It is freely accessible at odr.com, and you'll see that Anna's going to be doing a demonstration in a moment with me. And I just want to point out this one thing at the bottom of this slide, which just makes me profoundly sad and makes me understand that despite how much we have accomplished, there's just so much left to do. Researchers out of Arizona State in the US did this study, and they found that only 11% of mediators had information, domestic violence or IPV screening information, when they started their mediation. 11%. I found that very, very disappointing. So we've made progress, but we're not there. Anna, it's now your turn.
Okay, so in Maryland, where I come from, we had gotten together a few years ago, a work group formed by the judiciary, and we were looking at the way and whether contested child access cases that were slated for mediation were being screened for IPV. And years before, standards and guidelines had been developed, but it turned out that they weren't really being used uniformly across the state. So our work group really wanted to find an empirically validated tool that would be easy to use and that we could implement across the state. And that is what led us to Amy Applegate and Amy Holdsworth Monroe and the shortened MAISIC. We were aware of the original MAISIC, but it was pretty long, and in a court system that has limited resources and time and staff, we needed something that would be more efficient and that would help us, move cases along. So we piloted the use of the shortened MAISIC in Baltimore County, Maryland, in our Office of Family Mediation. We were lucky enough to have an in-house court staff, mediation staff. So we did screening and mediation all in one office. I would like now to go ahead and do that demonstration with Amy Applegate for you of the MASIC-S. So I'm going to need to be able to share my screen. Great. One moment while I pull it up for you. Okay, can you see that? Great. Okay, so if you go to odr.com/MASIC-S, this is what you will see. This is the version of the MASIC-S that is available on odr.com. This is the first page. You will notice on this first page that you will have the ability to get into a comprehensive guide that you can read through, and I would recommend absolutely reading through it before trying to administer a MASIC interview yourself. And there's also a video introduction link that you can click on. There are basic instructions for using the MASIC, for describing what it is and how to conduct the interviews. And in general, in male-female couples, we are going to interview the female party first. Amy, are you ready to go into it? Great.
Yes.
Okay. So just out of character for a moment, I'm just going to be putting gibberish into the boxes. Okay, Amy is the first party that I'm going to be interviewing today, so here we go. Okay, Amy, thank you for making time today to talk to me. I want to explain a little bit about this interview that we're going to be doing and what mediation is. So in family mediation, parties work together to try to make good decisions for themselves and their children outside of court. Mediators do not take sides and do not decide for the parties how to settle their case. But mediators do assist the parties in exploring ways to resolve any disagreements in this confidential settlement process. Before the parties start mediation, we ask them to provide some information about the situation. So I'm going to be asking you some questions today, but first I'd like to ask you to tell me, just in your own words, What brings you to mediation?
Well, I'm here because the court sent me here. I'm getting divorced from my husband, Gordy. We have a 12-year-old son, Brian, and I have pretty much taken about all I can take anymore, and I need for this marriage to end.
Now I'm going to be asking you a series of questions about your relationship with Gordy. We ask these kinds of questions to parties who are the parents of the children in the case, or if you were currently or you were previously spouses or significant others to one another. Your responses to these questions are going to be confidential, Amy. I am not going to share them with the court, and I'm not going to share them with Gordy or with his attorney. Your responses will only be used to decide whether or not mediation would be appropriate in your case, and if so, how to conduct that mediation. However, in answering the questions below, please keep in mind that if we have a reason to believe that a child has been subjected to abuse or neglect that hasn't been reported to Child Protective Services or to law enforcement before, we might need to make a report to Child Protective Services or to the appropriate law enforcement agency. Do you have any questions about that?
No.
You might wonder about some of the questions that I'll be asking, but it's helpful to think of it like a visit to the doctor's office. There, you're often asked questions that might not seem important to you or might not seem to apply to your situation, but they are important to the doctor. The questions I'm going to be asking now are important for deciding what kind of mediation would work well for you and Gordy, or if it would be better for you and Gordy to not mediate. So please just answer them to the best of your ability. And in answering these questions, what I'm asking about are things that Gordy might have done during a conflict, a disagreement, a fight, or in anger, or to scare or hurt you, but not while joking around. Any questions?
I think I got that. Okay.
Okay, and if you need to take a break or if you need me to repeat something, just say so. Okay, Amy, did Gordy ever, whether or not you were living together at the time, forbid you to go out without him?
Yeah.
Did he ever drive dangerously to scare you or when angry at you?
He's a terrible driver, but I don't think he did that when he was, what did you say, angry at me?
Yeah, did he ever drive dangerously to scare you or when he was angry at you?
No, I don't think so.
Did he ever physically abuse or threaten to abuse pets to scare or to hurt you or when he was angry at you?
We never had any pets.
Did he ever threaten to hurt someone that you care about?
Yeah, my best friend.
Can you tell me a little bit more about that?
Well, we had periods of problems, and I would sometimes go by myself or take Brian with me and stay at my friend's house. And at some point, Gordy started to threaten her.
Do you recall what Gordy said or did to threaten?
You want me to say literally what he said?
If you're comfortable sharing that.
I'm going to beat the shit out of that bitch.
Did Gordy ever threaten to hurt you, Amy?
Oh, yeah. Yes.
Okay, and can you tell me a little bit about that?
He did it both with his words, with his actions. If he didn't like what I was doing, he would say, you know what happens when you piss me off. I'm sorry I'm using these words, but you want me to use these words.
You're not going to offend me, Amy.
Okay,
it's
okay.
helpful for me to understand what happened.
Yeah, and sometimes he said similar things about what he said about my friend Minda. He said similar things to me.
When's the last time something like this happened?
Well, I moved out about 6 weeks ago, within the past few months.
Okay. Did Gordy ever threaten to kill you?
Yeah, he did.
Do you want to tell me about that?
Do I have to?
You do not have to.
Well, I'll just say that he threatened it. He threatened it a number of times using really vulgar language. And I was pretty scared when he did it.
When was the last time that happened? Do you remember?
That's been about I don't know, I think 6 months or so.
Okay. Okay, now remember, just a reminder, all of these questions are about things that Gordy might have done ever, whether or not you were living together at the time, during a conflict, a disagreement, or a fight, or in anger, or to try to scare or hurt you, but not while you guys were joking around.
Okay,
Did Gordy ever hold you down, pinning you in place?
it got to that sometimes, yes.
Did he ever scratch you or pull your hair or twist your arm or bite you?
I don't think so, no.
Did he ever slap you?
No,
Did he ever hit or punch you?
he punched me.
Did he ever kick or stomp on you?
Yeah,
Did he ever try to choke or strangle you or cut off your breathing?
yeah, he sometimes put his hand around my neck and pushed me up against the wall and held it pretty tight.
Okay. Do you remember the last time that happened?
No,
Did he ever burn you with something?
no, he didn't.
Excuse me. Amy, did Gordy ever use a weapon against you or threaten you with a weapon or something that was like a weapon?
Yeah,
Okay, can you describe that to me? What kind of object did he use?
well, he has a gun and he keeps it close by and he lets me see that he has it. So I did feel threatened by that. And when he's gotten mad, he's picked up knives. He's not actually used a knife or gun against me, but he has held them or held them towards me, and I felt very threatened.
When's the last time that something like that happened?
I think the last time he picked up his gun is when I decided I couldn't take it anymore.
Was that, you said you had separated about 6 weeks ago. Was that when that
Sometime
happened?
around then, a little bit
Okay.
before I moved out.
Okay. Did he ever demand or insist that you engage in sexual activities against your will?
Demand or
Demand or insist that you engage in sexual activities against your will?
I wouldn't say it was demand or insist.
Did he ever physically force you to engage in sexual activities against your will?
He did do that sometimes when I was asleep and he would come in drunk, and he did that, yes.
Did he ever follow or spy on you, destroy your property, or try to contact you against your will, or communicate in a way that made you feel frightened or harassed? So, for example, unwanted phone calls, leaving you threatening notes or text messages or voicemail, or putting threatening messages on social media, anything like that.
No, he doesn't do that. He doesn't do that.
Did he ever stand outside your home, your school, your workplace, or any other places where he had no business being, and in a way that made you feel frightened or harassed?
Yeah, he seems to be in a lot of places where I am, so I feel like that's not coincidental. So yeah.
Okay. Now, thinking about the questions that you've just answered or similar kinds of things, as a result of any of Gordy's behaviors, did you ever feel fearful, scared, or afraid of physical harm to yourself or to others?
Yeah.
And can you tell me a little bit about that?
Well, I'm pretty nervous about this whole process.
Okay.
So yeah. And I think it's mostly directed at me. I mean, he does hate my best friend. I don't think he would do anything to Brian. I mean, he loves Brian and he's proud of him. I don't think he would do anything to him.
Mhm. And as a result of any of Gordy's behaviors, do you currently feel fearful, scared, or afraid of physical harm to yourself or to others?
I'm afraid all the time.
As a result of Gordy's behaviors, have you ever received any physical injury, anything from a scratch or small bruise or swelling to a major wound, other severe injury, or permanent damage to you?
Usually when he did things, he didn't leave marks, but there was one time when he threw me so hard that I had several broken ribs, and I had bleeding, and I think that felt like a really bad injury.
When did that happen?
It's a while ago.
Okay, so more than a year or within the past year?
I'm not sure.
Okay,
It's hard to remember.
that's okay. Do you need to take a break, Amy?
No,
Okay. Did you have to go to the hospital or see a doctor when that happened?
I did, but I didn't. I told them I fell.
Did you receive a severe injury, so broken ribs, bleeding? Were you knocked out when that incident happened? Did you lose consciousness?
I'm not sure.
Okay. So I know we've talked about some of these things have happened in the past year. Would you say that his physical violence has increased in severity or frequency in the past year?
It's been pretty constant. I don't think it's gotten, well, it hasn't, since I've been out, yeah, I haven't had any, but it hasn't, it was always pretty much the same.
Okay. Did Gordy ever act extremely jealous or frequently check up on where you've been or who you've been with?
Yeah.
Was Gordy ever, I'm sorry, did you say something? Okay, must have been the video. Was Gordy ever successful in controlling your activities or your work, your contact with family and friends, or your access to money or financial information?
He was sometimes.
And are you afraid that Gordy would harm you during or after the mediation because of what you say or do in mediation?
Well, I'm afraid of him. I mean, I don't know what he'd do. I don't know what he'd do. I don't, yeah. I don't know what he'd do.
Okay. Okay, Amy, the next set of questions I'm going to ask is if you have any of these following concerns about Gordy. So any concerns about him overusing alcohol or prescription medications?
He drinks a lot.
Okay. Illegal drug use?
No,
Mental health problems?
I can't tell. He seems off to me.
What do you mean when you say that?
I think there's something wrong with him, but I don't know how to, I mean, I'm not aware that he's ever had a diagnosis.
Okay. Any child abuse or neglect concerns?
No, actually, he is good to Brian.
Does Gordy have any criminal history?
He has a couple of speeding tickets. You're not asking about that, are you?
No.
Okay.
And nothing else that you're aware of?
No.
Okay. Okay, so Amy, just to wrap up, do you think that there's any reason why you should not participate in this mediation?
I want to mediate. I don't want to have to see him in court.
Okay. Any current or past protective orders or restraining orders against Gordy?
No.
And as a result of the questions that I've been asking, do you have any concerns that you'd like to share about mediating or the mediation process?
Just want to make sure you're not going to tell them the things I said, right?
No, Amy, this is completely confidential. Like I said, I'm not going to share your responses with the court or with Gordy. If Gordy has a lawyer, I won't share them with him or her either.
Okay, I really do want to mediate in a way that isn't scary.
Okay.
So I hope we can do that. I mean,
What would help you to feel safe or more comfortable with mediation?
I don't think I want to talk to him directly. I think, yeah, I think I'd rather not have to see him. Is that possible?
Sure, sure. So if the two of you were in separate rooms and the mediator went back and forth between you, would you be comfortable with that?
Well, as comfortable as I can ever be with anything about.
Okay, okay. If the program decides that your case will go to mediation, Amy, the mediator will probably talk to you, just you ahead of time, about what the mediation would look like and what supports you would need to feel comfortable.
Okay.
Okay. Amy, give me just a moment here. And as an aside, breaking out of character, in this program, you will click these certification buttons that basically are acknowledging that you understand that ODR.com is going to give you a link for a downloadable PDF version of the whole interview, that you have not put any identifiable information into the form. In the beginning, I made a mistake. I put in Gordy and I put in Brian. You should not put any identifiers in because this interview will live in the ODR.com software. And so you do want to maintain confidentiality. So you're not using people's names or other identifiers. And this is your only chance to get that PDF. So you are acknowledging that you understand that as well. You would hit the submit button. And the program is going to give you your scores. So Amy, if you want to pitch in with any of this.
Yeah, I'd be happy to. And I would say that the way that ODR.com has set it up is that these things get deleted after we leave. So I'm not sure.
Okay,
Living
okay.
on. Colin Rule, who I worked with, he's the CEO of Mediate.com. It's a related entity to ODR.com, was very concerned about that. So, and the other thing I wanted to say is that when you do this, you would normally not be sharing your screen. Anna did that so you could see, but I normally wouldn't be seeing the questions and answers as she did it.
Right.
So if you look at what happens, you now have a score of 17 out of 24 possible points. That is very high. That's a very high thing. And you're also you're being directed to look at presence of current fear and whether there's been a report of severe or permanent injury. Right. So yes, this is among the worst. So now what ends up happening is, why don't you show them, Anna, how you would download this thing? Download your response here.
Sure. So, and and also it does ask you to check for those responses. You can scroll down to those questions to double check on the responses in case you don't recall right off the top of your head about the questions for current fear or permanent injury. So this would be a very high score. We would click this one. We have a score higher than 10 and a report of severe or permanent injury or current fear. So Amy reported current fear and as well broken ribs. So now you have a scoring form that is particular to this score that gives you instructions for how to handle the person, this case and the person you're interviewing and things that are recommended. In this case, you want to be you want to refer Amy to a domestic violence advocate. And it does give you a script, a suggested script for that. Of course, you should have available the contact information for the DV advocates in your area.
And I would just add one thing. When I always go immediately, there's a little link to download the interview. Download it as soon as you're done, name it as a document, put your confidential case number in it, and then that is your MASIC party evaluation form mother, father, or parent one, parent two, however you want to do it,
Mhm.
and save it. And then you go and pick out one of these. And Anna's going to talk briefly about these forms, just generally, because we don't have time to go through each of them now.
Right.
But they
Right.
are different depending on the scores. But I would
Right.
say probably this gives you a flavor of what it looks like.
Right. And basically you are recording whether or not, just based on this one party's interview, whether you think that mediation is appropriate. After you have interviewed both parties, you would make a final case evaluation about whether or not the case should go to mediation. Looking just back here on the ODR.com site, there is a blue button that you would click to download your results. And that, as we said, will give you a PDF of your entire interview. Okay, I would like to stop sharing my screen now and go back to the PowerPoint.
And just a quick reminder, if there's a problem and you end up in the wrong language, the way to change your language back to your selected language is to press the little globe icon at the bottom of the navigation panel on your desktop. And if you're joining us by mobile, click the more icon and select the language. If you're receiving the wrong slides, in the very middle of the top of your screen, you will click view slides and then select English. Thank you.
I do want to be mindful of time because it's 2 p.m. and I want Hilary to be able to talk to you about the things she wants to talk to you about. Basically, the next several slides, and you will be able to get copies of them, talk about the party interview that we just did, the various sections, and whether or not they are mandatory or optional. And you can also read about that in the comprehensive guide that is available on ODR.com for the MASIC site. Okay, Amy, is there anything else that you wanted to say before we turned it over to Hilary?
The one thing I would say is don't make promises to your interviewees. You're going to be talking to both interviewees. Remember that each one is going to have different things to say to you. There may be a time when you think you're maybe shouldn't ask the full set of questions to the second person based on what the first party has said. This is all covered in the instructions, but I'd be super careful about making commitments until you have talked to both parties. And you know what you're doing, and then you make a decision, and you'll see that in the forms that are on ODR.com.
Yeah, and just if the first interview was so bad that you are concerned about asking those IPV questions to the second party, in practice in Maryland, what we would do is we would still conduct an interview with the second party, but we would just be asking the general, have you ever done mediation before? You know, what are your thoughts about doing it this time? Do you have any concerns? Is there anything you think I should know? Okay.
Okay, so this has been such a great demonstration and walk through of so many important aspects of what we do as family mediators or as professionals working in the family justice system or working with survivors of family violence. So I'm happy to have a little bit of time now to just take that information and transfer it really into the example that I can share, which is the way in which we are using it in the court-connected family mediation service in Toronto. And I know that many service providers across Ontario are doing the same thing. And even though I'm speaking about Ontario practices, so much of this I know is taking place across the country in other jurisdictions, or is applicable because so much of the principles and best practices are the same. So I just point out the definition of family violence as it exists now in Canadian law. It's important to always start there, in my view, because it tells us the things we're screening for and reminds us that when we're screening, family violence does not just mean physical violence. And the MASIC-S is a great tool to help us keep that top of mind. We also keep in mind that the Divorce Act and related provincial legislation now requires that that these aspects of family violence are a factor that must be taken into account by courts and mediators and family arbitrators and parenting coordinators when assessing or considering the best interests of a child. So we have legislation that backs up what we're doing when we're using the MAISIC. In Ontario, we're really well positioned to take everything that Annamaria and Amy have discussed and apply it to practice for these reasons. And we're very privileged here in Ontario in that all courts are providing free on-site family mediation through Family Law Information Services. And you can see the service providers on the Ministry of the Attorney General's page here. The mediators providing these services across the province are strictly trained in a whole range of aspects of family mediation, but most particularly, they've all taken at least 21 hours of training in screening for family violence and power imbalances and applying screening tools like the MASIC and the MASIC-S. And yes, we started off with the Dove screening tool many years ago before the MASIC came along. And we must be accredited by the Ontario Association of Family Mediation or Family Mediation Canada. And both of those organizations require us to take this training and also to keep it current and updated. And finally, those mediators who are providing these services in Ontario's courts also are required by the Ministry of the Attorney General to apply a policy on screening and to meet very specific screening standards and to apply screening tools such as the MASIC-S. So we already have a qualified, competent group of mediators. I suspect that 11% statistic that Amy referred to may be a little bit higher in Ontario as a result of the standards for screening and screening training, and as well the I think high percentage of family mediators here who are accredited. I just point out as well, if you are accredited in Ontario by the Ontario Association of Family Mediation, you are required to follow that organization's policy on family violence and power imbalances, which requires you, the mediator, to individually screen all participants for the presence of risk of family violence or the risk of family violence or abuse or power imbalance. And that this must be done in a face-to-face, private and confidential interview. So we are not allowed to have somebody else screen for us. We have to do it ourselves if we're the mediator, and you can do it one-on-one, actually in person or by Zoom. But you must have this one-on-one meeting to determine which modifications may be necessary to ensure a safe, effective process of negotiation, or whether the case is appropriate at all. And this speaks to one of the questions earlier in the chat I noticed, which was, well, how do you handle those situations where one person is manipulating you? Basically, they're providing you answers to gain an advantage in the mediation around custody, say, or parenting time. And my answer is, that's not the purpose of this meeting. We screen to assess whether the case is appropriate at all for mediation, and if it is, to design a safety plan and supports for the parties. So we're not getting into outcomes when we're screening, by and large. So just to bear that in mind, this is all about process design and safe choice of dispute resolution process. And you'll notice in the interview, I thought Amy, by the way, and Annamaria did such a great demo. And this is really common where we have high risk cases and the person at risk very much wants to mediate, right? So we're balancing this tension. It's a process of self-determination, but it has to be safe. That's what the screening is there to determine. The other thing I'll just note is in Ontario, again, we're really lucky. We have family court support workers working out of every family law information center where these mediators are located. So mediators in Ontario not only are trained to do this, but they're also, they have access to the resource of domestic violence support workers who we can send people to for further support, including safety planning and the kinds of next steps that the MAISIC outcome would require us to take. We also in Ontario have information referral coordinators in every court, also working under the family law information centers, or most courts, I shouldn't say every single one. But this is again a cadre of like a level of quality support available to people who are experiencing family violence and who may want to mediate. So again, just we're well equipped to use the MASIC-S and to use it well in Ontario. Also in Ontario, we have some great remedies that can be used to get the parties into an intake meeting where this screening with the MASIC-S takes place. And we are, by the way, very much using the MASIC-S in Toronto. Under the family law rules, a judge can order parties to an intake meeting with a court-affiliated mediation service. Whether they mediate or not, after that, it gets them in the door. It gets them screened using the MASIC-S. Beyond that, mediation is voluntary. And just here is just and this is just the Toronto service, but these services, again, I want to emphasize, exist across the province, right? So you've got court-connected mediation. It's free. The mediators are experienced. They also usually, in many jurisdictions, speak languages that would be useful for the parties who may be coming in who don't speak English. Well connected, thanks to the information referral coordinators. These services are well connected to community agencies, whether shelters or interpreters or other supports for the family. And safety planning is very much a focus of the work that we do at intake. So that was the part of this that we didn't have time to get into today after the demonstration, but it lies at the core of what court-connected mediators do in Ontario. They screen for the purpose of assessing whether a safety plan is appropriate, and if so, helping the parties or the party at risk getting that kind of safety plan in place. I also just identify here an excellent tool called the iDetermine, developed by the Redwood Shelter in Toronto, and that's the link to it. It is a self-assessment questionnaire that leads to resources and supports, and I recommend it quite highly. So that's really all I wanted to touch on, was to take you through how the MASIC-S is and can be applied in a jurisdiction that has the supports available to make it workable. So with that, I'm going to pause and open it to questions.
Okay, thank you very much, Hilary. And there's Amy and Anna. There's lots of great questions accumulating. Let me just start with the first one. I think, I'm not sure you said it, you talked about the information you have is confidential. Does it matter whether it's open or closed mediation? That is, if somebody's concerned about accessing information, if a court subpoena comes to you and it's been open mediation and you're screening and they want the information about your screening, can they access that?
We don't have open mediation. So that's a great question. I'm not sure what open mediation means, because mediation by definition here in the States is a confidential process in virtually just about all of the jurisdictions. I would say there's one exception. On almost all the jurisdiction, facilitation could be an open process or something different. But that would be very worrisome. If that's the case, you need to be very careful about the screening, about the records.
If you look at the screen as part of the mediation process, which we do in our jurisdiction, we have a participation agreement, and it specifies in there that the parties will not subpoena the mediators, and it outlines confidentiality pursuant to the rules in Maryland, the rules of procedure. And
I'll just speak to Ontario. It's a really good question. The short answer is screening should always be confidential, whether it's open or closed mediation. And the agreement to mediate should make that clear, as Annamaria said. Having said that, a court has, everything is subject to being overridden by an order of the court, whether it's open or closed. So when one of the things I was going to point out is the introduction to the MASIC does need to be modified in each jurisdiction. So in our jurisdiction, Ontario, we would explain not only might I have to breach confidentiality of this intake meeting if a child is at risk of harm. I may, in that case, I have to report to a Children's Aid Society, but as well, there are very rare circumstances in our jurisdiction where mediators are ordered by courts to testify. that can take place in child protection mediations or possibly related criminal matters. And in those cases, I may be compelled to disclose even screening information. But it's not, it doesn't matter whether it's open or closed, is the short answer.
One of the important principles I think all of you touched on is the importance of not taking sides in mediation. Is there ever a time when you're not taking sides, but you have information about imminent risk of harm that you have to take action? So if you're doing screening and somebody discloses something about their partner escalating in the violence or purchasing a gun or like obvious risk markers, do you ever deal with sort of responsibility of reporting imminent risk of harm?
I would say that my MASIC, when we do the MASIC in my jurisdiction in Indiana, we disclose we are mandatory reporters for child abuse, unreported child abuse or neglect, or also abuse or exploitation of
Elder.
of incapacitated adults.
Yes.
But we also have a duty to warn. But that duty to warn has to be, I mean, it's not just I'm so mad I could kill him. It would have to be, and it would be more than just somebody having purchased a gun. Unfortunately, as you all know, the gun laws in this country are very liberal. So a lot of people own guns, but it has to be that you're aware that bodily injury is about to take place.
Yeah.
Then yes, I wouldn't they know.
Yeah, the imminent threat of harm.
Yeah, the imminent threat of harm is a very big deal.
That's standard language, again, in all of our agreements to mediate, and certainly when we're doing this interview, and just for everybody's information, in our court connected program, I have adapted the introduction to the MASIC-S for our mediators, and it's very clear that here are the exceptions to confidentiality, child in need of protection, imminent risk of harm to anyone I may have a duty to warn, and if a court orders me. So yeah, we have the same, somebody mentioned Tarasov in the questions. We have the very same duty to warn in Ontario.
And Peter, may I just add that the reason we don't take perpetration is exactly what we've been talking about here. And I think we touched on it briefly earlier, which is there is authority, at least in my jurisdiction and probably most of the jurisdictions, that a mediator can be compelled to testify in another proceeding. So, and that would usually, we're talking criminal proceedings, but it could be others too.
One of the participants raised the question, looking at your sample case, that you have you have a number of risk factors, including prior strangulation. Would you ever get to the end of your intake and worry about somebody being at risk of lethal violence, even though there's not a direct and imminent threat? There's just so many risk factors that you have to do something.
Right. That's why yes, I do sometimes worry. Yes, I worry based on what they say. I have to accept what each person says. That's why there is a mandatory referral to a domestic violence, we call them DV advocates. I'm not sure what you call them in your country, but we call them DV advocates. We can't force people to do it. And sometimes they're already there, and, which is great. But yes, it is a concern. And I try to be persuasive about them using it, but it is mediation. I can't force people to do things.
Would you
And
do
if you're working for a court program, you also have to be cognizant that you can't advocate for anybody. You're administering the screen to determine whether or not mediation is appropriate, not to be a social worker or an advocate.
God forbid. Would you ever do a follow-up? We have a question here from a number of people about if you finish an intake, you've seen both parties, and you're really concerned. And Amy, I take your point that there's not mandatory referrals to an advocate, but would you do a follow-up yourself a week later, just saying, I was concerned about all the things you mentioned?
I think that's a really fair question. I'm doing it in a more private setting. Cases are coming to me, but yes, I have been known to follow up with someone and say, I made that referral, and I was just calling to see how that went. And sometimes, for one thing, when I make the referral, I try to facilitate it so that I do more probably than others, but I would literally send an email to the advocate that I'm sending him to. And if it's safe for the interviewee to be included on that, it's not always safe for them because somebody's hacked into their email, but depending on a number of things. And I will be as helpful as I can, because I think they should have, this is safety planning that I can't do with them, but that they should be doing with an advocate, as well as deciding, is mediation the right approach for me in this circumstance?
Would you report children exposed to domestic violence, intimate partner violence, to child protection? That is, if you, as someone, you're doing the intake and someone's telling you about a number of incidents that happened that haven't been reported before. Take your case, if the children were present during the strangulation, or kids were impacted by how distressed the litigant was, do you reporting responsibility based on exposure to domestic violence as a form of emotional, psychological abuse?
And I'll just
Go ahead,
Anna,
Hilary.
answer that.
Ontario. So, I mean, there's two parts to it. First of all, yes, we all want to be really familiar with the definitions under the Child Youth Family Services Act, what constitutes a child at risk of harm. Certainly, exposure to family violence would most likely. But the other piece in the question was if it hasn't been reported before. So really important to know that whether it's been reported before or not doesn't matter. In Ontario, and I'm sure this is the case across the country, you have a duty to report any disclosure, whether you understand it to have been previously reported or not. So yeah, and we have protocols, and I'm sure all mediators do, for how you walk through that situation where you're realizing you've got a duty to report to a Children's Aid Society.
More sophisticated than us.
Definitely.
Way
My
more
response is, I don't really know the answer to that question. So I would ask one of my court social workers, they're without breaking confidentiality. Hey, what should I do? Does CPS want to hear from me in this circumstance?
Some people online are very excited by your tool and the presentation. They're wondering about other contexts. So you're describing a tool to see whether mediation is appropriate or not. Do you know other professionals, for example, someone's writing in who's an advocate, should they adopt this tool as part of their intake?
I think that's great. So I have been piloting this semester. Gosh, I feel like you work for me, Peter. And thank you, whoever asked that question. This semester I've been teaching, this past semester I was teaching a civil protection order clinic, and I adapted the MASIC and created it for attorneys. And I think it could be similar for advocates too. Because if you're an attorney, you can ask all those perpetration questions. There's attorney-client privilege. So I've done that. Is the person that you're saying an advocate, are they an advocate or an attorney? Can you clarify which one that they are?
Advocate.
Advocate as in a DV advocate?
Yes.
I think you could easily adapt it for that. And I think you could use it. And the thing is, we ask if you're going to start adapting the MASIC that you check in so that we make sure that the questions aren't being changed in a way that the questions have been empirically valid. Some of them have been, most of them have been empirically validated in some way or another. So we want to see what you're proposing to change. But yes, I think it's deplorable that, that attorneys don't ask these questions. I'm sorry if I'm hurting anyone's feelings. And I'm also surprised that advocates don't. And I'm also surprised when I hear when you've got a lethality tool like the danger assessment, why people aren't using that tool. That's a great tool, a great tool for an advocate to be using to sort of figure out if this person is really, what kind of risk they're at. But it's only for women. I mean, that's where the research has gone.
One thing
Go ahead, Hilary.
Across the country, for anybody who's interested, Justice Canada has developed the HELP toolkit, which was mentioned during my introduction. And I would recommend that everyone who's acting as an advisor to parties going through any kind of family law proceeding, take a look at the HELP toolkit. It's designed for family law legal advisors, and it's a great resource that I think a lot of lawyers across Canada now are familiar with and are using to ask some of these kinds of questions.
I think now there's some other questions. We just have a few minutes left. There's a question about whether, as part of mediation, you'd ever interview children to get their perspective on risk.
I'm happy to answer that question. I have interviewed children in my jurisdiction. The court can order it or the parents can agree to it. And I have in limited circumstances done that. That's because I am trained in interviewing children. I don't think it's a good idea to interview children if you don't know what you're doing. I also think we have implemented in Indiana, starting up on this child informed mediation that comes originally out of Australia from Jen McIntosh. And I'm a believer that the people who should be interviewing the children in these sorts of cases should be mental health professionals, not the lawyers involved. And I also think it could be used not just for if they're at risk, but actually if, like, how is the conflict? How is that situation affecting them? It's a beautiful experience to be part of the child-informed mediation process, particularly when the child is interviewed. There are two versions, child inclusive and child focused. And it was perhaps some of the most exciting work I've ever done. We did a study in my clinic of that too, but you didn't ask me to talk about that today, so that's all I'm giving you.
But I think the collaborative process speaks well to that, because then you can use a child specialist to work with the child, and they are a trained mental health professional, so they know how to interact safely with the child and bring that information to the settlement discussions.
I'll just say there's lots of resources across the country in different provinces touching on this. So you've got some great, if you're in British Columbia, there's some really good resources and agencies there. And this is very much a live topic in all jurisdictions here. Many people are trained to interview children in a number of ways. So I think it's a really important question that doesn't have a short answer, but other than yes, not necessarily in relation to specifically family violence to get their experience on that, but more broadly, lots of child interviewing going on and being done really well across the country right now.
The last question is one about whether the MASIC is appropriate in doing screening on same-sex relationships, and also is it sensitive to, I mean, we're using a lot of examples about women being abuse victims, which is more common, but are you also sensitive to men who are victims of violence, and also looking at cultural diversity and same-sex relationships?
It's set up that way. I wish that we, well, I know that we weren't able to do the study we did on mediation in DC on the comparing the specialized mediation to the court. We couldn't, there weren't enough same-sex couples to be included in the study. The percentages were too low for, to be able to be statistically okay. But we have set up the MASIC to include, I mean, it can be administered to same-sex couples. It could be non-binary individuals. I mean, we set it up, he, she, them, I mean, him, her, that. So we've tried to do that. I don't have any statistics or research to report, but I have certainly administered it in same-sex couples, and I use it that way and continue to do so. And I think every mediator in family law should be sensitive to, I'm going to call them the non-hetero couples, or the traditionally hetero couples. I think, of course, we should all be sensitive to that and be welcoming and inclusive. And so it's designed to be inclusive that way. I just don't know what to tell you about whether it's valid as to same-sex couples. We haven't looked at that question.
I think that's it. Thank you very much for dealing with some very difficult questions, and I really enjoyed your presentation. I'm going to send it back to Lisa for her closing comments.
Yeah, thank you. Thank you so much. I'd just like to echo Peter. This has been incredibly interesting, and you've taken this time from your busy practices, Amy, Annamaria, and Hilary. It's been very informative. And I'd also like just to thank you for so generously sharing all the resources that you gave us to pass on to the participants. I'm sure that's going to be interesting reading for everyone. And I have to thank our French language interpreters always, because they are wonderful. Caroline and Xiang, thank you very much for doing such a wonderful job. And lastly, I would really hope that you would take a moment to complete the evaluation form. You will receive a certificate of participation. The link will automatically show up when in your browser as soon as the event has ended. We really do rely on your feedback, and that helps us to do work going forward. So we look forward to seeing you all at our next event and wish you well. Thank you.
Thank you.